Mr. Link. See you. Do we have Mr. Blackwell?
Yes.
I can't.
Oh, sorry. One moment.
Great. Excellent. Thank you.
Thank you, sir.
Any preliminary things before we get started? Great. Okay. Good afternoon. Today is March 10th, 2022. We are the Board on Professional Responsibility, and we are here in the matter of Kenneth L. Blackwell. This is board docket number 2016-D396 and ODC docket number 20-BD-19. And the record should reflect that our Vice Chair, Ms. Pittman, Lucy Pittman, is recused from that matter, for this matter, and is not present here with us today. I assume, Mr. Blackwell, well, sorry, I should have asked the parties to identify themselves for the record. Could I ask ODC to go first?
Yes, Mr. Chair, my name is Miles Link. I'm representing the Office of Disciplinary Council, and we are appellees at this point.
Thank you. Mr. Blackwell, could you identify yourself for the record?
Yes, sir. Kenneth Blackwell, Respondent.
Excellent. Thank you. So I assume, Mr. Blackwell, you'll be arguing first. You've got 20 minutes. Would you like to reserve any time for rebuttal?
Yes, I would. One question, though. I noticed there's only 2 members present of the board, you and Ms. Larkin.
I'm sorry?
I only see 2 members of the board who are present. That's you and Ms. Larkin.
Yeah, I suspect that's a problem with the, are you viewing this on an iPad?
Okay, now I see more. I put it on the gallery screen and I can see.
Yeah.
I can
Excellent.
see.
Yeah, gallery view is going to be your friend.
Okay, I see 5 members. So it'll be 5 members of this
Nope.
board?
Nope, we've got 8.
Okay, I cannot see the other ones. Let me see.
What,
I can see all 8.
great. What device are you viewing us on, Mr. Blackwell?
It's a laptop computer.
Huh.
It's an older model, so I don't know if that's a factor. But I can.
Well, I'm not sure quite what to do with that. We could pause and go off the record and see if perhaps you could work with someone in the board office to correct that.
Okay, I think I've done it.
Oh, have you done it? Excellent.
Yeah, I've done it. So I can see 1, 2, 3, 4, 5, 6, 7, 8. Yes.
Great.
Okay.
Excellent. Very glad to hear it. Okay. So how much time did you want for rebuttal?
I suppose I have 20 minutes initially. Is that correct?
20 minutes all told. 20 minutes total. And so is there a portion of that you'd like to reserve for rebuttal?
Yes, I would say 8 minutes.
8 minutes for rebuttal. Okay.
Yes. Now
Great.
I can see Mr. Jim Phelan. Is he present?
So he's with the board staff, and there should be a function if you go to hide non-video participants, that then you're just looking at the folks who have their video on. It's a little bit easier view. You should be able to see Mr. Link, 8 members of the board, and then a clock.
Okay. All right.
Does that work, Mr. Blackwell?
It does. I can see everyone
Okay.
except Carly Jordan and Jim Phelan.
Great. Yes, you shouldn't need to see them. Don't need to see them.
All right.
Okay, so just preliminary things before we get going. We're on Zoom, as everyone knows. Please mute yourself if you're not talking. That way it makes the sound a little bit easier. Mr. Link, Mr. Blackwell, if the board members will have questions, I'm sure, try to be mindful. Let us kind of get in and ask questions. The convention we've adopted, people will raise their hands if they have a question. So try to keep a lookout for a board member with a hand up. That means they've got a question for you. And I'll try to interrupt if it looks like that process isn't working smoothly. With that, Mr. Blackwell, you've got 12 minutes. Please start whenever you're ready.
Thank you very much, sir. Good afternoon, everyone. As everyone knows, this matter before the board involves child support orders that were issued in the state of Maryland between June 2007 and December 2010. These orders, with the exception of the 2010 order, required that child support payments be made through the Office of Child Support in Maryland. I admit that I did not make those payments through that office. Instead, I made those payments directly to Ms. Allen. After 2010, the order was in 2010, rather December 2010, December the 7th to be exact, the order was modified so that payments can be made directly to Ms. Allen. After that point, I did make payments to Ms. Allen. I've been charged with failure to obey the court order with respect to failure, not making the payment to the Maryland Child Support Office. But at the same time, I'm accused of violating the order with respect to not having made the payment to the Virginia Office of Child Support. The record, however, shows that I was under no obligation, no duty whatsoever to make a payment through that office. However, that contention has been used to amplify the sanction that's being recommended, is being used to somehow suggest that payment was not made after 2010 because there's no record of payment to that office. But the record will show, the evidence will show that payments were made directly to Ms. Allen. The record will show that Ms. Allen indicated, yes, Mr. Walker.
Thank you, Mr. Blackwell. Are you saying that you made all payments as required under the relevant court orders?
Well, after 2010, I did. I was able to maintain the amounts that were due.
So you are saying that after 2010, you were not in arrears with respect to any of the court-ordered payments?
I may have been because of the fact that I didn't keep a record of what was paid prior to that time. So because of that, I may have been, but I can say with certainty that after 2010, that I was not in arrears.
Is that consistent with your testimony during the hearing before the hearing committee, where in at least a couple of places, on at least a couple of occasions, you certainly seem to be conceding that you did not make all payments, that is each and every payment as required by court order?
Well, I was conceding with respect to what I've just mentioned, that I did not keep records prior to 2010. And so I was in a position where that was the best of my recollection, that perhaps all payments had not been made. But I made it clear that I was referring to that period of time, not subsequent to 2010.
Well, go ahead.
All right. The Disciplinary Council also, in the course of this investigation, it presented a question to me. And that question, the committee found, was ambiguous and subject to interpretation. And based on that, the committee made its own interpretation. And based on its own answer, it concluded that I made a false statement. I challenged that on several grounds, as I've elaborated. So I won't go into any more detail on that. Also, I was never charged, of course, with any violation with respect to Rule 84C. And even considering that, the arguments in 8.1 deals with that contention. Overall, I submit that several things occurred in this proceeding as well, which I took exception to, and Disciplinary Council did not address. One of the most fundamental ones was the deprivation of due process. And that dealt with the fact that we kept a history of payment, Ms. Allen and I, of what was made after 2010. When she filed her complaint in 2016, she claimed to have lost that record in 2018. I made requests for that record before that time period, well, not actually before, but as soon as the charges were presented to me, I immediately made requests for that document. Disciplinary Council never informed me. The only thing they said was they had no knowledge of it. And that the record shows by their response to my discovery motions that they indicated they had no knowledge of it. When they turned over the files, they didn't even produce the payments that I had made. So I had to file a motion for exculpatory evidence. This was months after they were supposed to have given me everything in their files that I was entitled to. But I was compelled to file a motion for exculpatory evidence. And then they produced a record of payments that I had been made to Ms. Allen by way of money orders that she had cashed. Throughout this proceeding, Disciplinary Council maintains that I did not make the payment, that I willfully refused to make payment. This is absurd. To get a better understanding of the context of this case, yes, sir, Mr. Walker.
So with respect to these notebooks, weren't these notebooks that maybe you said this, that you and Ms. Allen were supposed to maintain together?
No, it was one notebook and we would exchange it. Whenever the child was exchanged, the notebook would come to me, I'd make notations, return it to her, then she'd make notations, return it to me, vice versa.
And did you not maintain your own copy of the notebook?
No, because it was in a binder of this nature. It was in an actual composition book, a notebook. So there was no copies made of that. And actually,
when was the last time you had seen this notebook before requesting it in these proceedings?
Sometime in, I would say, 2018.
And that was how many years before these proceedings?
That was 2 years before the proceeding and 2 years after I received notice that a complaint had been filed.
Okay. And what is the basis for saying that there was a failure of due process by Disciplinary Council with respect to not providing those notebooks? How is it their obligation as a matter of, well, what's the basis for claiming a due process claim? And then what would the remedy be that you're seeking?
Well, the basis would be that there was an unexplained delay. And this delay occasioned and a failure to preserve that evidence, which Disciplinary Council knew or should have known at the time the complaint was filed in 2016. So Disciplinary Council did nothing apparently. Well, they claimed to have conducted an investigation, but they should have known or should have inquired about what payments were made, since the allegation was made that no payments were made. In fact, when I received communication from that office in 2016, I received a statement which indicated that 0 payments had been made. So I immediately knew that was false. And once the charges were filed, well, I responded that was false. I responded that payments were made. And I heard nothing else from Disciplinary Council for 2 years, actually nearly 4 years. And at that point, the claim was made that that information was lost.
Doesn't the failure to, or the lack of ability to review the notebooks, doesn't that just go to the amount that was paid or that was not paid? It doesn't really go to the question of, so it goes to the amount. If you are conceding, and perhaps you're not, if you are conceding that you did fail to make some payments, then isn't it just a matter of what payments were made, the amount, and doesn't go ultimately to the 3.4C issue? In other words, how is this a basis to dismiss? Doesn't it only go to a question of the exact dollar amount that was paid?
I understand that. I wasn't arguing it as a basis to say that that charge 3.1 is not substantiated. I was directly, to your point, indicating it as failure to prove a substantial payment was not made. The hearing committee made a strong point that disciplinary had proved that there was not substantial compliance with the court order. So that proof of payment would indicate substantial compliance. And as the committee mentioned, that will go directly to mitigation of sanction. So
Well, what is your basis, Mr. Blackwell, for saying that in order for there to be a 3.4C violation, that there has to be proof that there was not substantial payment? Isn't it enough that there was a partial lack of payment to provide a basis for a 3.4C charge? Where does the word substantial enter into that rule or to compliance with that rule?
that it goes, well, I'm not arguing that substantial goes to whether or not there was a violation. It goes to mitigation of sanction.
Okay.
It also goes to, well, it definitely goes to mitigation of sanction, but moreover, it goes to the prejudice that was caused by the failure to preserve that evidence and the delay that was occasioned, which caused that evidence to be lost. Yes, Ms. Sargent.
Yeah, Mr. Blackwell, I'm still lost on this point of, do we know, please tell me if I misunderstood the record, didn't look at it closely enough. Do we know, does ODC say, and I can ask Mr. Link this, does ODC say they had the notebook?
They never acknowledged even an awareness of it until the eve, not even the eve, they never acknowledged it at all.
So I don't want to interrupt you, but I do want to be clear on this. You're saying that you and Ms. Allen maintained one binder notebook that is your only record of what you paid her after 2010.
No, it's not the only record. The evidence in the record shows, she admitted, first of all, that payments were made from 2010 to 2014, and that she didn't have a problem with that. That was her testimony. I could cite that in the record if you needed to do. She also indicated that payments were made to her that she told the Virginia Department of Child Support Enforcement to give credit for. She also acknowledged that payment was made to her in cash. The testimony also was there that she refused payment from me.
Okay, but you're saying this notebook, this binder notebook went between the two of you as some sort of record of what you paid, right?
Absolutely. Absolutely.
And you let it out of your sight. There was, regardless of what you're citing to me about Ms. Allen's admissions, you're saying that you had no independent, no receipts from the money orders, no indication on your tax returns of how much child support you paid, just this one binder. And because I want to get to this point of, why are you alleging that ODC failed to preserve records if we don't know? Do we know that ODC ever had this binder notebook in its possession?
Well, ODC never acknowledged it. But the point I'm making is, once the complaint was filed, ODC had an obligation to conduct an investigation. Part of that investigation was to find out what the validity of her charges. If ODC sent me a letter after the complaint was filed in October and sometime in December stating that, Ms. Blackwell, our records show you made 0 payments, 0. If ODC is going to make that allegation, they also had the obligation to make sure that was accurate. They also sent me a letter from the Virginia Department of Child Support Enforcement indicating that 0 was paid. So if they're making that allegation, it has to be based on some type of good faith effort. I'm suggesting that part of that good faith effort goes to, I believe it's Rule 8.1 of their obligation to investigate, their duty to preserve any evidence, especially exculpatory evidence, and proof of payment certainly is relevant to any allegation they're making. It goes, I'm sorry, Mr. Walker.
Did you mean Rule 3.8?
It's the rule that requires
special responsibilities of a prosecutor.
Yes, sir.
Doesn't that only apply to a prosecutor in a criminal case?
No, I believe Disciplinary Council has conceded at other hearings that it applies to Disciplinary Council as well. They have an obligation to provide exculpatory evidence. So it applies to Disciplinary Council. And again, Mr. Miles himself conceded to that at a hearing previously.
Well, but you're not arguing that they had the notebook and didn't share it with you. Your argument is that they had a duty to do a really, really, really full investigation, and they didn't find the notebook, which I guess you're arguing means they didn't do the right investigation, and that's what the due process violation is. Is that your argument?
That, and as well as the delay, which occasioned
Sure.
that. Because had, for example, charges filed in 2016, had they filed, or rather the complaint filed in 2016, had they filed a charge in 2017, we wouldn't be discussing this notebook. So it was the delay. Then not only the delay was compounded by the fact that they didn't even turn over exculpatory information at the time they produced their records to me.
So let me make sure I understand that. Your argument is that because of the delay, if the charges had started earlier, you would have known to hang on to the notebook, presumably, or disciplinary counsel would have gotten it, but the notebook then would have been found and in play at the hearing. And that was substantial or evidence that you think was really important, and that you were prejudiced by not having that evidence available at the hearing. Is that your argument?
It is.
Okay, great. Thank you.
And
Sorry
that's a delay occasion that those whole series of events.
Okay, great.
And,
Go ahead.
well, keep in mind that disciplinary council did not even address the delay, either before the hearing committee or before the board. That in itself suggests a lack of duty on their part, or even a lack of thoroughness in terms of their obligation to present sufficient evidence. And also they knew or should have known that it would have hampered my ability to present a defense, which it did.
Okay, we're past time for your initial presentation. I know you've got a meaningful amount of time in rebuttal. So why don't we turn to Mr. Link at this point and hear what disciplinary counsel has to say, and we'll come back to you in a bit, Mr. Blackwell. Mr. Link, whenever you're ready.
Thank you, Mr. Chair. With respect, I think respondents' arguments, both here and in his briefs, are models of misdirection and obfuscation. We asked the board to consider the record in this proceeding and the hearing committee's very thoughtful, careful, and comprehensive findings of fact in its report. We think the hearing committee did a very good job. We refer you to finding of fact 66, in which notes that the allegation which we received was that Mr. Blackwell was in arrears by $50,000 in his payments of child support. That clearly is not substantial compliance at all. I want to go over what the record shows as to what he paid in child support. Between himself and his brother, they paid $3,100 to the Maryland and Virginia courts. That's finding this facts 48. He testified that he paid $1,500 to Miss Allen in April of 2013, an unspecified amount in May, and that he paid $6,500 to her in 2016 and $5,000 to her school. He offered no records of these payments other than his own testimony. His sister testified that she paid Miss Allen a total of $2,000. That's finding of fact 50. Ms. Allen testified that for the 13 years between June of 2007 and December 14 of 2020, respondent paid a total of $10,000 directly to her. That's less than $1,000 a year. Respondent did not provide an alternative amount, and his failure to pay.
Mr. Link, I'm sorry, I'm trying to just on your first point, did you direct us to finding of fact 66 for the total number that wasn't paid?
No, I directed you to finding of fact 66.
I'm sorry, I was flipping pages slower than you were talking. I'm sorry about that.
Yes, it's finding of fact 66. It's on page 26 of the hearing committee's report.
Because that doesn't, it looks like that's not a finding that 50,000 was the amount in arrears. It said that she filed a complaint alleging that it was 50,000.
That's exactly that's what I said. I said that was the allegation that disciplinary counsel received, which prompted this investigation, and that was a substantial amount which justified and supported an investigation.
Sure. Yeah. No, 50,000 is a substantial amount. I'm with you on that. I guess I'm wondering, and maybe I missed it, and if I did, I apologize. But did the hearing committee make a finding of fact about the amount that was in arrears?
The hearing committee was unable to make a total finding of fact as to the amount in arrears. It did note that the Virginia Office or Department of Child Support Enforcement noted as of, I think, 2014 or thereabouts, about $12,000 or $18,000 in arrears. So, his failure to pay child support adversely affected his child as specified by the hearing committee in finding of fact 52. With respect to this, so I mean, this was clearly a matter that justified an investigation by the hearing committee. With respect to this notebook, I'm reminded of the Hitchcockian phrase of a MacGuffin. This notebook was never in the care, custody, or control of the Office of Disciplinary Counsel, period. It's interesting, in the absence of this notebook, respondent can claim anything that was in it, and there's no way to determine the veracity of those claims. I would point out, yes, Mr. Walker.
Given that it's a MacGuffin, let's not spend too much more time tracking it down then. I'd like to get to the 8.1A charge, if we could.
Yes.
The question, do you agree that the question asked by Office of Disciplinary Counsel on which this charge is based was ambiguous and poorly worded?
No, I do not. And I do not for the following reason. And I'll refer you to the question. Let me just read the question. It says to Mr. Blackwell, you state that you never, quote, willfully failed to make child support payments pursuant to any court order, close quote. If you have not, quote, willfully, close quote, failed to make court-ordered child support payments, do you agree that you have failed, however, to make the court-ordered support payments? And he said no, which means he did not agree that he had failed to make the court-ordered child support payments. But given that the court orders required him to make these payments to a child support enforcement agency in Maryland up until 2009, and in Virginia after at least 2014, and he did not do so, and given that he never paid the full amount of child support he was ordered to pay by the court, nor did he ever claim that he had paid the full amount that he was ordered to pay by the court, the hearing committee was completely justified, and I would argue required by the record and by the Court of Appeals decision in the shorter case to find that his answers were disingenuous and not credible. He knew that
two things on that, Mr. Link. First of all, wasn't the shorter case an 8.4C case, and how does that transfer and translate to 8.1A? And second of all, I think you're glossing over the position of the respondent here, which is that he took that question to mean, did you fail to make all the payments? And his answer was no. And so is that on its face an unreasonable interpretation of the question and an unreasonable response? So there are a couple of compound questions in there, but taking first the application of shorter here, if you would.
Yes. The issue in the 8.4C and in the 8.41 issue, as applied in this case and shorter, is similar. It relates to the honesty of the respondent, or the honesty of the lawyer in here responding to a question which he knew that ODC was asking about the status of his court-ordered support payments, and he knew that ODC was investigating Ms. Allen's complaint that he ignored the court orders to make the child support enforcement payment. So as the court said in shorter, a over-technical reliance, particularly when it's done by a lawyer who understands the reality of what the question is seeking, is not sustainable.
Well, shouldn't that have been charged then as an 8.1B violation, which really has a reasonableness standard in it and goes more, it seems to me, based on the language of the rule, to an evasive answer, as opposed to a knowing false statement? why wasn't this charged under 8.1B instead of, or at least in addition to 8.1A?
Mr. Walker, it could have been charged under 8.1B and 8.1A. Disciplinary Council does not like to overcharge, and so 8.1A was charged because he knew that he was giving this answer in order to defend or justify or provide exculpation for his not complying with the court orders. And so his interpretation, you suggested he interpreted by saying, had he not made all of the payments, one could argue he interpreted it to mean, had he not made any payment. And so he is saying, I've made some payment. We would argue the question asked, had he made the court-ordered payments? He's a lawyer. He understands what that means. He had not complied with the court orders. Therefore, his answer was false. Ms. Sargent.
Mr. Link, now, your point about not overcharging would be a good one if it wasn't for the fact that subsection B, 8.1A and B are two different things. One is a false statement. One is an unreasonable response, sort of a lack of candor kind of a question, right? I mean, would you agree with that?
Yes.
And I think you're doing a very admirable job of trying to defend the question, but the question was kind of a 2-3 part compound question, and the answer could reasonably be read as there's insufficient indication that it was actually false. So I guess what I'm trying to get at here is by choosing to charge 8.1A, you're now stuck with having to show that it was a false statement. And by foregoing 8.1B, you don't have the leeway to argue that it was unreasonable, that it was just unreasonable.
Ms. Sargent, that's an excellent point, as was Mr. Walker's. We do disagree, however, that 8.1A is not appropriate. And again, I would point you to the question. It wasn't a compound question. There was a predicate, but the question itself was, and I quote, do you agree that you have failed, however, to make the court-ordered support payments? The only honest answer to that question is yes, I've failed to make the court-ordered support payments. The question doesn't say, have you failed to make any, or have you failed to make all? It says, and the court order required payments through the Maryland Child Support Enforcement Agency. And then when the matter was transferred to Virginia, the Virginia courts required that the payments be made through the Virginia Child Support Enforcement Agency. He had not done so. There was a brief period of time where he and Ms. Allen, this was between 2010 and 2014, had agreed that he would make payments directly to her, and the Maryland court accepted that agreement. In 2014, Ms. Allen appealed to the Virginia Department of Employment and Child Support Enforcement because he was not abiding by that agreement. He was not paying the amounts due, and he was not making regular payments. And so Virginia courts got involved again. The Virginia Office of Child Support Enforcement got involved again, and he still continued to fail to make his child support payments. In fact, so for him to say, when we were asking this question after this period of time, that he had complied with the court order, there is simply no definition of honesty which would allow his answer to that question to be considered an honest answer to that question. Mr. Walker. Mr. Walker, you're on mute.
Yes, I was trying to find my, thanks, Mr. Lake, I appreciate it. And thank you for answering those questions. I want to go back to a somewhat more basic question posed by this case, and that is that this is a case of first impression in applying Rule 3.4C in the District of Columbia to discipline an attorney for failure to make child support payments. Why this case as a case of first impression? Why isn't this matter covered instead by the DC statute that calls for suspension of license proceedings with through the clerk of the court referred to the board when an attorney fails to make payments. So first, why are we proceeding here in this matter? This particular matter is a matter of first impression, and why isn't this a matter to be resolved through the statute as opposed to directly through the disciplinary process?
Thank you, Mr. Walker. First of all, this case, as all cases, come before first a hearing committee and then the board after an investigation by disciplinary council, and disciplinary council has to present its conclusions to a contact member of a hearing committee serving as a contact member who has to approve a proceeding before it can go forward. In fact, as the board knows, in some cases, a contact member may insist that a matter go forward, and the office does so. In all cases, this matters don't go forward without the concurrence of a contact member, and that happened in this case. Whenever the Office of Disciplinary Counsel gets cases, we investigate each one on their merits. In this case, we had a substantial allegation of non-compliance with a court order, $50,000. We had responses by the respondent that were, in our view, disingenuous. We had notices from both Virginia and Maryland that court orders had not been complied with. Respondent had been found to be in contempt of court in both Virginia and in Maryland. So we felt that a prosecution under those circumstances was appropriate. With respect to the District of Columbia statute, DC Code section 46-225.01, that statute does not, which was adopted pursuant to federal law, that does not provide an exclusive way to pursue these claims. And under that statute, professional licenses are supposed to be suspended for professionals who are not complying with child support orders. But that is not the exclusive remedy. And in fact, that statute authorizes, one would say directs, the Board of Professional Responsibility to adopt rules and proceedings to address the statutory scheme. That, with respect, has not yet been done. It directs the clerk of the court to notify the board when a lawyer has not complied with their child support obligations. In fact, in the District of Columbia, unlike in some other states, the District of Columbia clerk of the court does not maintain records on whether a member of the bar is in compliance with child support obligations. So the statutory scheme with respect to lawyers is simply non-workable in the District of Columbia. It simply doesn't address the realities of the procedures in the courts. However, it is not an exclusive remedy. And in virtually every other jurisdiction which has addressed this issue, Rule 3.4C has been the route that they have followed to hold attorneys responsible for child support obligations. There are a few states, and we discussed this extensively in our brief. We felt discussing extraneous issues like due process were not really what the board needed. We wanted to discuss this issue because we think it's important, because this is a matter of first impression for the board. Some jurisdictions have adopted specific rules to address this. I mentioned Florida, for example, but most jurisdictions have not. And 3.4C is the rule. And I would note that in this case, Mr. Blackwell has conceded the applicability of 3.4C to this violation. He argues that, well, we should have allowed followed the Maryland statute. But again, as I pointed out, the District of Columbia statute, but as I pointed out, the DC statute simply doesn't address the realities of the licensing process in the District of Columbia. Mr. Walker?
Thank you, Mr. Link. You answered a complicated question there. I'd like to turn to the sanction question, if we could. And here, rather than a compound question, I hope I'm asking three different questions. One is, even with a 3.4C and an 8.1A violation, assuming those are supported, isn't 90-day, isn't a 1-year suspension with all but a period of 90 days stayed, isn't that 90-day period outside the range of other 3.4C cases? What makes this so much more egregious as to merit that 90-day period? That's one. Two, what would your sanction argument be if an 8.1A violation were not found? And three, and this is a complicated question, how exactly do you see an order reading that would, with which the respondent here would be required to comply, and how could he go about complying if it requires some showing that he's made payments during the period of suspension? How could he make those payments if he's suspended from the practice of his profession? So that's a very difficult question, the last one. Exactly what do you see that order looking like? But one, the 90-day period. Two, what if there's no 8.1A? And three, the order.
And can I pile on to Mr. Walker's question and say you can imagine that such an order, with apologies to everyone really, you could imagine that such an order would specify an amount of money that Mr. Blackwell is supposed to repay before he can start practicing law again, but it doesn't look like we know the amount he's in arrears. And it seems like putting in he should just pay whatever amount he's in arrears is, you know, kicking the can in a way that may not be completely helpful for anyone.
Thank you. Let me try to address all of those questions. I start with something I want the committee to take into account. I want the board to take into account. The hearing committee went out of its way to give respondent the benefit of the doubt in this hearing. And I refer you in particular to its discussion at page 22 to 24 of the report about his difficult relationship with the child's mother. And also its discussion at pages 47 to 56 and 56 to 60, particularly page 58, where they go out of their way to say respondent, you know, was dealing with a difficult situation. And so it's in light of that that they nonetheless conclude that a 90-day period of suspension is appropriate because of his failures to pay his child support arrearages, because of his vexatious conduct before the hearing committee, because of his effort to evade ODC's questions during its investigations. And I think they reluctantly came to that decision. And again, if you read the report, that's the only conclusion I think you can come to. If an 8.1A violation is not found, Disciplinary Council recommended a 60-day suspension. We think that is equally consistent with with other cases finding violations in 3.4C, and we would recommend that. But we do think, for the reasons I've already indicated, that the hearing committee was correct in its finding of an 8.1A violation. In terms of how the order would read, the hearing committee has proposed an order in which the Virginia Office of Child Support Enforcement would provide a certification that the support payments were being made, or in lieu of that, the respondent would provide an affidavit in which he averred that the payments had been made and he would show evidence that they've been made. Mr. Chairman, your question, how do you make the payments if you're suspended from the practice of law, is an interesting one. And I would argue that the Congress in the first instance and the District of Columbia Council in the other have said, nonetheless, professional licenses should be suspended from persons who have failed to make child support enforcement, who have failed to comply with child support enforcement orders. I don't feel capable or competent to go beyond what the Congress and the Council have determined. In two instances in this proceeding, relatives of respondent came forward, one instance his brother and another instance his sister, to make payments on his behalf. If respondent were suspended from the practice of law for 90 days or 60 days, there are, I have no comment or knowledge about respondent's financial situation or about his access to funds to make the payments required. But again, a determination has already been made by the responsible legislative bodies as to how these matters should be addressed. And it would be inappropriate for me to go beyond that.
Great. Do you want to take 30 seconds and wrap up, or I realize we're over time, but you've been here before. We're not necessarily great at clock following.
I've concluded my remarks.
Excellent. Thank you very much, Mr. Link. Mr. Blackwell, I believe you have 8 minutes left for rebuttal, which is up on the clock. If you don't mind, I have a question to start, Mr. Blackwell, but if you want to start making some remarks, I hate to deny you the chance.
Well, if it's where I have additional time, because it's going to obviously consume my 8 minutes.
Well, I mean, we're going to be asking questions during your 8 minutes anyway, but go ahead, start talking. You're good. You're good.
Okay. Let me say this. I'm amazed that Mr. Link continues to make false statements. He continues to claim that I had an obligation to make payment to the Virginia Office of Child Support. That completely contradicts the hearing committee's report at page 72, the inclusion of law, where the committee states, ODC is not established by clear and convincing evidence that Virginia could nullify or modify the order or could require respondent to pay through VDCSE. So that statement he made was clearly false, that respondent had an obligation to pay them. With respect to the testimony.
Mr. Blackwell, am I wrong that that's just like a technicality, that you weren't required to go through the Virginia agency, not that you weren't required to make payments, right?
That's a distinction without a difference, because the fact is I wasn't required to. The only way I was required to, and as the evidence showed, and it shows at page 13 of the hearing committee's report, though actually of my reply brief, that could have been required for me to do, but it would have to be a change of payee, a designation of a change of payee. And Ms. Allen didn't even know what that was. She didn't execute one, and disciplinary council didn't approve. So saying that I should have paid to them, you could just as well say I could have paid to anyone, because there was no obligation. The obligation under the order was to pay to Ms. Allen. Yes, Ms. Cassie. Ms. Cassie, you're on mute.
Yeah, thank you. Mr. Blackwell, I just want to understand this argument you're making. Are you suggesting that the Virginia court had no authority to command you to pay child support payments?
No, but that did not happen. So having the authority and exercising the authority is two different things.
Okay, so explain your theory, if you could, about how they either didn't have the authority or they did not have the right to exercise the authority.
All right. Well, the hearing committee acknowledged that, and I've cited the statute in my post-hearing brief, that Virginia did not have the authority to modify the order from Maryland. They could enforce it, but they could not modify it. The order stated clearly that payment is to be made through or to Ms. Allen. So the court did not have authority to make that direction. Now,
can I ask you a question, Mr. Blackwell, about that notebook? Mr. Link said that the notebook is a MacGuffin. He is apparently more of a Hitchcock fan than I am. I'm not really sure what that means, but I'm assuming that's something that doesn't exist. No, Ms. Sargent, it does exist. I don't know. Forgive me.
It's like a fake thing, a fake relevant
like
distraction.
Thank you. Mr. Blackwell, like, is there anything in the record, and forgive me for not digging in on this one before the oral argument, is there anything in the record? Did Ms. Allen provide testimony about the existence of the notebook? Like,
absolutely.
How do we know
Absolutely.
Sorry?
Absolutely.
Okay, great.
She acknowledged it, and the court acknowledged it, the hearing committee rather, and the hearing committee tried to minimize it by Ms. Allen's testimony, which she stated is possibly, that the notebook possibly contained payment information. Now, I would expect that from Ms. Allen, who the hearing committee found was hostile, openly hostile to the questions. But imagine her admission that the notebook possibly contained information of child support payments not only proves its existence, but it proves the contents. Yes, Mr. Orr.
Yes, I guess I'm still unclear as to how the existence of this notebook and the fact that disciplinary council didn't locate it or whatever obviates your own obligations to maintain records as to how much you paid in child support, especially given the fact that you're an attorney, you know how important records are, I presume. How does that obviate your own obligations to maintain how much money you paid to your ex-wife for child support?
That's an easy answer, sir. I mean, if I'm already having a record that we're maintaining, going back and forth with the child, then to say that I could have had other records, that's easy to say. I mean, that's like, if it's cold outside, I'm wearing one coat, you could say, well, you should wear two, you could wear three, you could wear four. But the reality is, I think we need to stick to the facts. And the facts are that that was in existence that contained the records. We could always extrapolate and say what should have been done. But was there a duty for me to do that? No, none whatsoever. So that sufficed for what we did. And to my detriment, the delay cause is non-existence. If I may continue, Mr. Link also referred to the fact that Ms. Allen testified that there was only $10,000 made over the course of 13 years. If you look at her testimony, that came as a result of a series of leading questions, which was objected to, and she was led into making that conclusion. Furthermore, is it credible to believe, as many times as Ms. Allen had gone to court over the years, that that would have been the case, and she would not have gone to court to make this complaint? She went to court to make complaints about child abuse, which was unfounded. She made complaints to suspend visitation. As a matter of fact, I need to bring the court or the hearing committee's attention to this. The hearing committee, if you want to get an idea of who I am and whether I actually did that, look at the parenting agreement that was made in 2004. When Ms. Allen immediately went to court to try to get custody of the child, made a false representation that I was going to take the child to Boston, I drafted a parenting agreement. The parenting agreement said that each party shall have a full contact relationship that supplying for the child's material, spiritual, economic, every need. It also goes to, and talks about the child being raised with the principles of God. It also talks about child support being made by me of half the amount. I wrote that agreement. In 2012, when the child was subjected to abuse by Ms. Allen's boyfriend, I wrote another agreement. That agreement stated that this agreement should not affect child support at all, that my obligation to pay still exists. This is what I've done over the years. Despite whatever happened, I consistently tried effort with all my power to not only be in the child's life, but to also support this child. It would be ludicrous to think that I would expend such an effort to my child and display such a degree of love and compassion, but not provide financial support.
Well, Mr. Blackwell, let me get back to that point, which is the nub of the matter here. During your testimony before the hearing committee on page 237 of the transcript, you've said, and you say, I've already testified that I did not make, I wasn't sure, and I don't believe that and you say a double negative, that I did not make payments to the extent that was ordered. I don't dispute that. So if there's any doubt in your mind, I'm making it clear again. But the fact is, I made far more payments than Mr. Lowry alleged. And then you go on to say, of course, it doesn't exonerate me from whether or not I complied with the order of the court, because I did not to the extent that the order was, but it certainly goes to the egregiousness. So do you stand by that testimony that you made before the hearing committee? Again,
I do, because of the fact that during the period from 2007 to 2010 or 2009, I did not keep records. I paid Ms. Allen directly.
Okay, and so let me then ask here, did you make all required payments under the relevant court orders? Did you make each and every one that was required, yes or no?
Again, my best answer is I really don't know, but my best guess is I did not. That's my best guess. But what I can't, because again, 2007, 2009, I did not keep records. The payments were made when money came in periodically, as the transcript of before the court shows.
Surely you don't need documents for you to remember whether you ever failed to make a required payment? I mean, surely you don't need documents to answer that question more, yes or no, without saying to the best of your, I guess.
Well, first of all, we're talking about a question that pertains to a period of what, 13 years ago? That's number one. Number two, we're talking about a period of time when I was not making payments monthly as the court order required. So overall, we're talking about a period of time that actually was almost 18 years ago. So, and at the time I was asked the question, that was in 2020. So to the best of my recollection, no, I did not. But again, my recollection is clear that since 2010, I did. In fact, as I mentioned, and it's in the transcript, there's a finding of fact, Ms. Allen testified she had no problem with the payments from 2010 to 2014. I also indicated that we kept records during that period of time.
Mr. Blackwell, why don't you want to take 30 seconds and sort of wrap up?
Yes, Mr. Link mentioned falsely that I was found in contempt in Maryland. That's not true. With respect to the finding of contempt in Virginia, that was a deprivation of due process. The hearing committee found that. The court would not allow me to present witnesses or evidence. And if this committee wants to, or board wants to stand behind that finding, then there's obviously no justice whatsoever. With respect to the statute, DC statute, the DC statute does what this committee failed to do. The DC statute presupposes a finding that the obligor is in arrears, something that this committee could not determine, something that this committee struggled with. So when the statute makes a recommendation to the board, it's already made the determination that there has been arrears. This committee was not able to address that. With respect to Mr. Link's find that the committee went out of his way, the committee did not go out of his way. If I just need 30 seconds. What brings
you had 30 seconds. Last point, Mr. Blackwell.
It is. What brings this procedure into ill repute? And not saying that the system is, but if there's ignoring of the evidence, if there's manufacturing of the evidence, such as the ambiguous question, the fact that we're discussing this question as being ambiguous or not, what his meaning is indicates it's not clear and convincing. And finally,
thank you very much for your time, Mr. Blackwell. Appreciate it. Thank you for your argument, Mr. Link. The case has been submitted.
Thank you, sir.